Tom Edwards, and I represent TSE Plantation, which is now known as Echo River Sanctuary. As I stand here today, the plaintiff, 21st Mortgage, has a void lien under clear first DCA precedent, and you don't need to look far in the record to reach that conclusion. At page 359 of the record, the pretrial stipulation admitted the date that the bankruptcy was filed by Mr. Harrell, and it admitted the first time they ever filed their lien, which was 2 to 3 months later. So at the time they filed their lien, there was an automatic stay in place, and that renders under both Florida and federal case law the lien that they filed void and a nullity.
Let me ask you this, Mr. Edwards. We have a mobile home here next to the property, homesteaded. If we were to find this was real property, is that an automatic reversal?
Yes, sir.
And why is that?
Because if it is real property, it went with the land when the foreclosure took place. The lien was void. The bankruptcy had been filed when they filed their lien, and that renders the lien a nullity under both Florida and federal law. Because the lien is void and it was homesteaded, when the property was foreclosed by Center Bank, the mobile home would have gone with it.
But doesn't 320.015 say that it's to be considered real property only when the owner of the land is on it and it's permanently affixed there too, and it stays personal property until the loan is paid off?
That is what that statute says. However, the Florida common law for many years is that you can have that private agreement through contract between the bank and the owner of the property or the owner of the mobile home. But the agreement is not binding on anybody that is not put on notice of it.
But you were on notice of it when you purchased the land, right?
I became on notice of it after I'd already contracted for it. Center Bank is the entity that took the mobile home in the foreclosure.
After you contracted for it, but before you closed?
Yes, sir, but Center Bank is the entity that foreclosed the mobile home. And Center Bank was never put on notice of it, and they admitted that on cross-examination in the trial.
But under the circumstance of this case, what makes the mobile home real property?
What makes the mobile home real property is, number one, there was no lien on it, and this lien was not perfected because it was void. And what made it real property is the owners of the mobile home owned both the land and the mobile home. So under Florida law, it's then a part of the property. The tongue had been taken off. It was put on blocks. It was permanently affixed to the land. It was skirted, and it was connected to utilities. And when you look at the Solomon case, which we cite in our brief, they actually reversed a trial court under similar circumstances with similar facts because the trial court found that a mobile home was personality as opposed to real property. And under these facts, they held no. If there's a clear indication that it is a permanent residence, that this company required these people to sign paperwork when they were filling out the paperwork to get the loan on the mobile home, specifically stating that it was their permanent residence. And they then, after they closed, they homesteaded it. They had a real property sticker put on it, and the company was paying the real property taxes on it for numerous years thereafter without objection.
Did Citrus State Bank ever claim an interest in the mobile home?
Yes, they did. Well, they did not have a mortgage on the mobile home. Center State had the mortgage on the entirety of the property, and if you look at the judgment entered by the foreclosure judgment at page 719 of the record, the foreclosure judgment at page 7 of the judgment at 719, paragraph 20 specifically recites not just real property but everything on the property. It discusses liens on anything else on the property.
So the bankruptcy court addressed the mobile home in the Harold's bankruptcy proceedings.
They did not, because the defendant, or rather the plaintiff, never told them they had gone and taken this lien. And under the Schwartz case, they make crystal clear, if you take action against a bankrupt person, you have a duty, if you take any further action against them after the bankruptcy, to notify the court and to address that with the bankruptcy court. They concealed all this from the bankruptcy court. And that's why we had gotten previously in unclean hands summary judgment that then got reversed because I hadn't buttoned up one issue. That they engaged in conduct where they misled the court with filings that I've described in the brief by filing stuff talking about this being worth $30,000 when they had just financed it for $81,000. They never told the bankruptcy court that they had gone and filed a lien. And when you look at the Oldham case, which we have cited, they recite similar conduct involving a mobile home, and they state that this is exactly what the stay is supposed to stop, and it is unscrupulous conduct for a creditor to engage in this kind of conduct, concealing it from the bankruptcy court. It is their duty to go to the bankruptcy court to get relief from the stay, and they didn't do that.
I'm sorry.
Well, I wanted to circle back to the statutory section, Mr. Edwards, and sub 2, 320.015 sub 2, as you know, says any mobile home classified by a seller or a lender as personal property at the time a security interest was granted therein to secure an obligation shall continue to be classified for all purposes related to the loan and security interest. So it would be your position that for all purposes related to the loan and security interest would only deal with parties to that agreement?
Yes, sir. The common law at that time said virtually the same thing, and this became codified. And what they didn't address in any way, shape, or form are the cases in common law that said third parties are not bound by this. There's nothing in that statute that says anything about third parties being bound by this. The legislatures presume to know the common law, and they don't change or reverse common law unless they do so expressly or the wording in the statute is so expansive that it's clear they intended to reverse the common law. There's nothing in there about the impact on third parties. It is a discussion about which is what common law cases said, that if they have this contract, then they have an agreement that its personality is between those two persons or entities. And their problem in this case is every aspect of how this mobile home was dealt with, it was a piece of the real estate, it was homesteaded, and they knew all of this. If we step back from what was going on here, and I think it's important to keep this in mind, they worked with these people to go in and take a mobile home that was on the property throughout the life of the foreclosure, remove it from the property days before the foreclosure summary judgment hearing. They didn't inform the court, they didn't inform the bank, they didn't inform anybody, and they've admitted all that.
Did the bankruptcy court address whether or not Premier First Mortgage violated the automatic stay?
It was never presented to them because nobody ever knew about it.
Can I ask you about the title? Ms. Harrell didn't file for bankruptcy. So if they don't own the property, the mobile home is tenants by the entireties, the lien, at least as to her, is valid. The title, as I understand it, just says Mary Lynn Harrell and Curtis Robert Harrell. Doesn't say tenants by the entireties, doesn't say as husband and wife. Why does this create a tenancy by the entirety?
The Beal case speaks to that. There's a presumption of tenancy by the entirety when there's a married couple.
But it doesn't say they're a married couple.
But page 35 of my brief, I gave multiple different, the title doesn't have to say that. If there's any evidence that they are married, then it is a tenancy by the entirety. And at page 35 of my brief, I listed out the mortgage that was originally on all of the property said they were married. The loan application with 21st Mortgage referenced that they were married. The bankruptcy schedules referenced that they were married, and the title was issued jointly. So under the Beal case, it is presumed to be a tenancy by the entirety.
The bankruptcy court ultimately revoked the Harrell's
No, sir, and we've provided a case that's very, very similar to the Oldham case, which is a bankruptcy case, which explains why it doesn't. And in that case, the party's bankruptcy was also dismissed. And the Oldham case explains why, and actually Oldham, Schwartz, and Keitel all explain why, for public policy reasons, a violation of the automatic stay must be treated as void, because otherwise you put the onus on the bankruptcy court, the trustee, the creditors to go search out what everyone else is doing improperly. And that's where, when you look at the Oldham case, they talk about why this is considered unscrupulous and inappropriate conduct. And keep in mind that 21st Mortgage's own people have testified, we're in bankruptcy court every day. We've got a bankruptcy department in our legal department in our corporation. That they are aware of this. And they did not tell the bankruptcy court what was going on. And after having had these mobile homes traded out immediately before the foreclosure judgment was supposed to be entered, without telling anybody about it, that they moved forward. And I'm just about out of time. That they moved forward and did this regardless, and never told the court about it, never told the trustee, never told anybody what they were doing. And that is categorized by bankruptcy judges as unscrupulous and inappropriate conduct.
Thank you, Counsel.
Thank you.
You may approach, Counsel.
Thank you, Your Honor. Good morning, Your Honor. I'm Todd Morgan on behalf of 21st Mortgage for purposes of arguing this case today. Your Honor, I would contend that we're really dealing with two issues here with respect to this appeal. The first issue is whether Echo River or TSC Plantation has standing to raise issues that it objects to that occurred both in the foreclosure action and the bankruptcy court, which are all commenced many years before they ever purchased this property. And the second issue is that what I believe is a deliberate confusion by Echo River contending that there is no valid lien on the property.
Why is this not real property? Explain to me how you can affix this to the land, have a septic tank, homestead, pay homestead taxes, and this not being real property. I don't get that.
Well, that's what the legislature decided when they passed statute 320.015. It specifically says you can have this property declared as real property for purposes of paying property taxes, because I think you save some money if it's all included with the real estate. But section 2 of that section says it depends on what the intent was of the parties. And in this particular,
Well, what about the Constitution? I mean, this is a constitutional homestead. Doesn't that trump the statute?
no, Your Honor, because in this particular case, the statute says the parties to this transaction can agree that it's going to remain personal property until the lien is paid off.
Well, but I hear you as to the individuals, but the state of Florida has declared this to be a homestead. Has it not?
The Heralds declared it as real property for purposes of tax reasons.
I hear you, but I mean, the
I'm-
tax collector is collecting homestead taxes on this, or did during the time this was in place, and it was paid for by 21st Century, correct?
Yes, because as is usual, it is escrowed, and we paid it as part of the escrow. I know it's real estate was registered as real property, obviously. I don't agree that the.
Would you agree that if it's real property, you can't prevail based on the theory advanced? Because the theory advanced, replevin, only applies to personal property.
If the court says it's real property, then it cannot be replevin. I will concede that point, but I don't concede that it is actually real property. I don't think that was
And I understand, thank you, Mr. Morgan, you made that clear. But given the pleadings below, the pleadings presupposed it was personal property, correct?
Correct.
So if it's real property, then the complaint, the theory evaporates.
Well, if that's the constitutional argument that the statute is unconstitutional, I think that should have been brought at the trial level, because we haven't addressed that.
Well, I'm just trying to reconcile. We have the Constitution, which has been recognized in this case. Taxes were paid pursuant to that constitutional provision. It looks to me that to the extent this statute runs afoul of the Constitution wins. And I understand it hasn't been raised by Mr. Edwards, but isn't it a de novo standard by this court to evaluate all these claims, given the legal determination made by the trial court?
Well, I think the court can do what it wants to do with respect to how it addresses issues, and it's not my position to tell the court what it can and cannot do. But I do think the Strickland case that was decided by the Florida Supreme Court specifically said that if you're going to declare something real property, they have a three-prong test. One, it has to be attached to the property. Two, it has to be hooked up. And three, there has to be intent of the parties to declare it real property.
Well, thank you. Attached to the property, hooked up, and the intent is we're paying homestead property taxes. So how is it not all three elements?
Because it wasn't the intent of the parties that the mobile home would be considered part of the real property. It was because of the contract that the Herald signed with 21st Mortgage, they both agreed that it would remain personal property until the loan was paid off.
And that was a part of the mortgage agreement?
I guess it's a security contract. I don't know if it's exactly a mortgage, but yes, it was part of that. It's on the first page of the agreement.
When did the Herald acquire mobile home?
November 2010, I believe, November 6th or November 8th, I'm sorry.
How does the bankruptcy filing by Mr. Harrell fit into all of this in your point of view?
Well, I don't think that what happened in the bankruptcy court is properly before this court, and I don't think any alleged violations of the bankruptcy are properly before this court, because I think that would be something that would be determined by the bankruptcy court. I think the bankruptcy court has the right to determine whether there was a state violation or not. The bankruptcy court never faced the issue, but certainly.
But there was a state violation. These liens were issued during the stay. Isn't that true?
They were issued after the bankruptcy was filed, but we contend that they were authorized under Section 362B because we're allowed to perfecting our interests subject to the trustee's interest in the property. And I would point out that neither the trustee nor the Heralds ever raised any issue about this during the bankruptcy. Mr. Edwards has made a lot of speculation about what went on in bankruptcy and that bankruptcy court didn't know this or didn't know that. But in reality, the bankruptcy court knew everything. This was a two-creditor bankruptcy, and the only two creditors were First Guarantee Bank, who had the mortgage on the real property, and 21st Mortgage that had the security interest on the mobile home. So to suggest that an experienced trustee and a debtor who was represented by counsel didn't know what was going on with respect to this mobile home is sheer speculation on Mr. Edwards' part.
What is it about the Herald security agreement with 21st Mortgage that makes it a mobile home personal property?
Because the language in the section says that the parties agree that the mobile home will remain personal property until the debt is satisfied. And the testimony at the trial was the debt was not satisfied, there was still a balance outstanding. So as long as the debt was not satisfied, then it remains personal property, and the court, that section specifically says it still remains personal property irrespective of whether or not it's been declared real property for purposes of taxes. So again, I realize there may be a constitutional question about it, but as far as the statute itself reads, we had the agreement and it remains personal property pursuant to that
So
agreement.
is it your position that anything the Herald did after the entry of the security agreement involving making the property real property, that is, apply the homestead exemption, smooth? Or is it irrelevant?
It's moot with respect to the classification of it, because the statute, again, it says, yes, you can have it declared real property for purposes of property taxes and paying taxes on it, but it's still going to stay personal property because this is a lien on, it's a secured debt and there's a lien on the property because of the contract.
Going back to the title question, what do you contend the title to the double wide, how was that held?
The title to the mobile home was held by Mr. and Mrs. Harrell. And again, only Mr. Harrell filed bankruptcy. She did not file bankruptcy. And then 21st Mortgage has the first security title to, Mary Harrell and Curtis Harrell. It didn't reference them as husband and wife, it didn't reference them as joint tenants, it didn't reference them as tenants in common, so,
So what is your contention in that Florida law makes that?
I think it arguable, it could be either way. I don't think there's any clear-cut presumption that it's a, tenants by the entirety, and I think if that was the position that was gonna be taken by, Echo River, then they should have, brought the Heralds in to testify about that. They could have easily done that. But again, with respect to, filing the bankruptcy, since Mrs. Harrell didn't file, and since it was a Chapter 7 bankruptcy, there was no co-debtor stay in the bankruptcy court, which only applies to Chapter 13. So we were, legitimately entitled to go ahead and finish, perfecting our lien on the title, but I still contend we, did it validly pursuant to Section 362.
If you have a valid lien as to Mrs. Harrell, but we find you don't have it to Mr. Harrell, were you entitled to replevin?
I think that would be a questionable, right, we might have to go back and, reapply for the lien on the title, to do that.
Why is that?
Well, if you're saying I didn't have, my client didn't have a valid lien, if it's, even if it's owned by tenants by the entirety, obviously, you'd have to have both parties. If it's owned tenants in common or somebody like that, we would only have an interest in half of the mobile home. I mean, we could repossess half of it and have to, make some agreement with Mr. Harrell. So if you said, no, it's not a valid, replevin against Mr. Harrell, I think we would have to at least go back with respect to him. But-
Was Mr. Harrell a party to the recovery proceedings below?
Mr. and Mrs. Harrell were named as defendants, but they didn't get personally served, so therefore, we were not able to, go forward with the monetary judgment against them. However, the summons was posted on the mobile home, which, because it was a, replevin as an in-room proceeding, that satisfies the requirements of service and process, because if the parties who own the property have abandoned it or can't be found, then we're allowed to, post notice on the property. And the assumption is that they haven't come back and seen the summons, then they've abandoned it, so, we were able to proceed against the property at that point. And Echo River, or TSA at the time, was served, well, they intervened in the case, so we didn't have to serve them, and therefore, they were noticed because they actually, they're contending that they have possession of it because it was on their property, so they were, named in the amended complaint so that we could, get the right to replevin against them.
Does Echo River having, notice of the lien before they closed on the property have any impact on this?
I think it does, Your Honor, because they're asserting, oh, we're not bound because we're some third party that doesn't know about this contract. I mean, I question the legitimacy of that complaint, because that would enable, parties to two-party contracts to assign it at the end and suddenly deprive somebody else of their rights, and I don't think anyone wants to do that. But in this particular case, Mr. Edwards knew about it, and he intervened in the, replevin action itself, the company intervened itself just to, establish that right. Furthermore, by knowing about the mobile home, they listed the, VIN numbers in their, agreement with, First Guarantee, and all they had to do was check with the, Department of Motor Vehicles, and that would have shown that, there was a lien on these properties. So if he didn't have actual note, or if the company didn't have actual notice that there was a lien on the properties, they certainly had constructive notice because they were aware of the lawsuit because they intervened. They were aware of the VIN numbers. They could have found it if they used due diligence in doing that. So we think that, would relieve the excuse that, no, we didn't know about it. So, I also want to tell you that we contend we do have a lien. The issue between the title and the lien is perfection of the lien, but we have a lien pursuant to our contract with the Heralds, and no one else has come in and alleged a superior lien to us, because this property was not transferred through the foreclosure, because it was not a part of the land at the time the foreclosure was filed, and the certificate of title did not list any of the, titles on the mobile home, which would be necessary to transfer that with the certificate of title. Furthermore, when Echo River purchased this property from what was now Centerstate Bank, Centerstate specifically said, we are not making any representations to you that we own these mobile homes on the property. We're specifically saying that we're not, giving you title to any mobile homes. And obviously that was to protect them for the deed purposes. So it was clear at the time this purchase was made that there was that there was a question about the title and that 21st Mortgage was there and was going to assert the title. If I can just briefly address the issue on appeal that we raised, and that was a scrivener's error in the final judgment. As important as the final judgment said a writ of possession as opposed to a writ of replevin, and that was strictly a scrivener's error. The action that was filed was for an action for replevin. The evidence was presented for replevin, and we had asked the court to overturn the final judgment to that respect and ask the trial court to issue a writ of replevin instead of writ of possession, because we can't take property unless we have a writ of replevin. And my time is up, and I thank you for your attention.
Thank you, counsel.
Please, the court.
You may continue, counsel.
Let me try to address some of the questions that were asked, but before I do that, let me say as to the scrivener's error, it wasn't scrivener's error. The judge entered the order they asked for, and a writ of possession gives them the right to possession of the mobile home if they win. That is what they asked for as against me. They're trying to expand, I explained in my brief, they're trying to expand claims after the fact, and the judge has declined to do that. So let me speak to the issue of the Judge Bilbrey that you've raised about the title. The title actually specifically references that they take ownership jointly, meaning both Curtis Harrell and Mary Harrell. That's recited in our brief, and I recite to a statute that says when they do that, it is joint ownership. But more importantly, please read the Beal case, because the Beal case speaks to these issues. It is a Florida Supreme Court case that came out just a few years ago that speaks to joint ownership by married people and the presumptions that go with that. And if there is any evidence presented at trial of a marriage, it's their burden to then come in and show that it's not joint ownership, not tenancy by the entireties. This was a tenancy by the entireties, and their own corporate representative admitted in the trial that taking a lien against Curtis was improper and had an effect on him. Creating the lien, even if they took the position they were doing it as to Mary, it had an impact on Curtis also at a time when a bankruptcy was in place. They admitted that, and I cited that in my brief. The issue of me not having standing is rebutted very, very clearly in the U.S. Supreme Court case of Fuentes v. Shevin. In that case, it involved a replevin statute in the state of Florida, and they spoke to the state of Florida replevin statute. And what the Fuentes case says is there is a due process right to hearing and to contest if there is a deprivation of possession and use. It doesn't say anything about ownership. Ownership was contested in that case. So we absolutely have the right to be here and contest this and to challenge what they've done. There are a couple of other things that really concern me that they've argued. If you look at their brief and you look at what was argued to the trial court, they've argued that they're authorized to do this and that they can sidestep the bankruptcy code and the bankruptcy stay order that is automatically put in place without any citation to a single case anywhere, despite us citing to numerous cases that say you can't do this. And they simply threw out two statutes. If you read my brief, I had to go through and analyze their complex statutes. I had to analyze every single element of those statutes and went through and showed how they had nothing to do with this case. They were in violation of the bankruptcy stay, and they concealed it from the bankruptcy court. They never told them about it. And they say that I don't have any basis for saying that. I put the bankruptcy record in evidence that showed that they never revealed to the court what they did, and I cross-examined their corporate representative on that issue, and they admitted that they never told the bankruptcy court anything about it. That is improper, and it's what a bankruptcy judge has called unscrupulous conduct by a sophisticated client, by a sophisticated entity that appears in bankruptcy court based on their testimony presented at trial on a daily basis. I'm about out of time. If there are any questions any of you have, Judge Jay, I can tell you we raised the issue of homestead throughout the trial, pre-trial and post-trial, and so we have raised the issue of homestead trumping this issue.
Thank you, counsel.
Thank you.